Hello, hello. Today we have something very interesting to talk about because not only does this affect the Stauch case, but it affects the Murdaugh case as well. Now, it's very interesting when you start talking about juror bias or jury um, tampering, which is what happened in Murdaugh's case, and we have jury bias in Stauch's case. But the only way for the state to overcome not having a new trial is for them to file a writ of certiorari with the Supreme Court and let them hear it. Now, that is what we're going to talk about today. We're going to talk about other cases that this has happened in. We're going to talk about um, cases that have had juror bias before. We're going to talk about all of it. So get ready, get your popcorn, sit down, get happy. This is going to be a while. It's a lot to explain, and we're going to explain it as best that we can. So there you go. That is what today is about. Now, I've also pulled up, and we're going to use this as we go along because I find it interesting every time we talk about Letitia Stouch's case, we have to talk about Dr. Lewis because you can clearly tell in that testimony exactly what she was doing because you have to remember Dr. Lewis is a DID person. Also, if you remember, we watched Jenny Hayes' story the other day, and she also is DID. However, hers is real, not made up. She wasn't pretending. She actually had the trauma to support her DID. And I think that story was very, very telling. So, but I wanted to compare the two, Jenny, the real McCoy, to Letitia, the fake person who wants to, wing everything she can. Just she lies about everything. She's a habitual liar. So anyway, we're gonna show this a little bit of this again today because it's kind of interesting. Um, and I know it has nothing to do with the biased jury, but it does has a lot to do with that case. So here we go. I'm going to share my screen so we can look at this when we're ready. Another thing that we're going to talk about is the actual. Let me fix this over here. Whoops. Hang on. We got to skip that. I'm going to skip the ad. So just give me just a minute to skip the ad, and we'll get it ready to go. Ad over there. I don't want we have to have ad. Skip the ad. Okay. Now let's stop right there. We'll put it right there. We're going to make it big so we can come back to it when we're ready. Okay. So there is that. Okay. Now, the other thing we're going to talk about today is Alex Murdaugh and his what happened in his trial and the overturn of his conviction as well by juror tampering. And I want to show you that right quick. So let me share the screen on that one. Share the screen. Here we go. Right here. Now, let's talk about this for just a second, and then we're going to move on to the writ of certiorari because both cases have to have the same. The state has to do the same thing in both cases. Now, will they do it? I don't know, but they should do it. They don't want to do a new trial. The expense of the new trial versus trying to reverse the Supreme Court's reversal by filing the writ is the simple answer. It is not an easy process. It takes a while for it to happen. It takes a while to get it written. Once they get it turned in, and the Supreme Court takes the time to look at it, or even decide if they want to look at this opinion, they may not even want to look at it. They may just say automatically, "Nope, we're not going to look at it," and then it goes back down to the trial court, and they have to start all over. Another thing about this case that's odd is when we talk about Letitia Stauch's attorneys, there is no way that those same two attorneys will take that case again. It's just not going to happen. It's not going to happen. So let's go ahead and look at Murdaugh. I know everybody's covering Murdaugh. I know that, but I do want to talk about it for just a second. So let's look at where the story comes from in the People magazine, which is what I have. There we go. Let me get this pulled up. All right, now. This is from the former. Let's see. Let me get this over here. I'll get rid of that. Okay. The former Colleton County Clerk of Court, Rebecca or Becky Hill, pled guilty in December 2025 to perjury-related charges for letting the press view sealed exhibits and lying in court about it. Now, South Carolina Supreme Court justices agreed this week with Alex Murdaugh's attorneys, who argued his trial was unfair due to the jury interference by former Colleton County Clerk of Court Rebecca Becky Hill. Hill reportedly made comments to jurors about Murdaugh's testimony and the defense's case. Oh, go away. She pled guilty in December. We just talked about that. The South Carolina Supreme Court said interference by the former county clerk was grounds for appealing Alex Murdaugh's double murder conviction. Murdaugh, who is 57, was convicted in 2023 of fatally shooting his wife Maggie and his 22-year-old son Paul, and the family's 1,770-acre hunting property in Allenton, South Carolina. 2 years earlier, jurors deliberated for less than 3 hours before delivering the guilty verdicts. He was subsequently sentenced to 2 consecutive life sentences. Now that the former attorney, who's long maintained his innocence, may possibly head to trial again after judges unanimously agreed that former county clerk Becky Hill improperly influenced the jurors. Since his conviction, Murdaugh's attorneys have argued that he was denied his constitutional right to a fair trial by an impartial jury free from outside influences per the appeal. The post-trial hearing revealed more details about Hill's comments to jurors when Murdaugh's attorneys portrayed him as guilty. Okay, so one juror identified as Juror X testifies in 2024. Let me make sure that I have this shared properly. Hang on a minute. Well, I don't have it shared properly, do I? Hang on, let me get down to where I was. All right, here. Get back on StreamYard so I can see. All right, let me make sure I've got it right. Here we go. It's right here. Are we sure the right one? Here we go. Okay, now. All right, let me keep reading down here. All right. The hearing also focused on Hill. Okay, I left out a part. Sorry about that. During the hearing, Hill denied most of the jurors' claims, but acknowledged by telling the bailiff, hang on, we left out a part. One juror identified as Juror X testified in 2024 that before Murdaugh took the stand, Hill told jurors it was important or epic day, noted it was rare for defendants to testify, and it is rare, they don't normally testify. Juror X said that the remarks did not affect the verdict. The appeal also alleges that Hill told jurors not to be fooled by the defense's case and urged them to watch Murdaugh closely during his testimony, including his actions and movements. Another juror, Juror Z, testified Hill said, as deliberations begin, this shouldn't take us long. And Juror Z also said she had doubts about Murdaugh's guilt, but voted to convict because she felt pressured by other jurors. Okay, that is very bad. During the hearing, Hill denied most of the jurors' claims, but acknowledged telling the bailiff within earshot of jurors about Murdaugh's decision to testify. She also admitted giving jurors a brief talk, calling it a big day, and urging them to pay attention, while denying any attempt to influence the jurors per the appeal. Hill was also questioned about favors she granted to the media. In court, she denied letting the press view sealed exhibits, but pled guilty to it in December of 2025 to perjury and other charges tied to that denial. She subsequently received 3 years probation. That's all she got for ruining this trial. Now, I want you to think about that. That is all she got for ruining this trial. 3 years probation. Not enough, is it? No, it's not enough. Okay. The hearing also focused on her book about the trial, Behind the Doors of Justice, The Murdaugh Murders. Hill denied wanting a guilty verdict to boost her book sales and said the trial's outcome did not matter to her. Still, the appeal notes that she acknowledges writing that she believed Murdaugh was guilty and worried he could be acquitted because of his family's goodwill in the community. Murdaugh's appeal was initially rejected by Judge Jean Toll after his hearings. However, on Wednesday, May the 13th, now here's the thing about this as well. We also heard from other creators who said they had it in their ear that it was going to be reversed, but they had not seen the actual opinion because the actual opinion did not come out until today. The court opinions in South Carolina come out on Wednesdays. That is why it came out today. Just a little information about South Carolina. Now, however, on Wednesday, May the 13th, the South Carolina Supreme Court unanimously overturned his murder convictions and life sentence, paving the way for a new trial. He will not be released. He is still in prison for the financial crimes that he committed. He's not going to get out on bond. None of that will happen. Okay. Regardless of the decision, Murdaugh will remain in prison, where he is serving concurrent federal and state sentences totaling a decade for financial crimes committed around the time of the killings. South Carolina's Attorney General Alan Wilson said in a statement that his office will aggressively seek to retry Alex Murdaugh for the murders of Maggie and Paul as soon as possible. So that is the outcome with that. That is what's going to happen with Berdahl. Now we're going to go back to Stauch. So hang on just a second. We're going to go back to Stauch now. Let me switch this gear. We're going to pull this other one back up. Share the screen. Okay. Whoops. Oh, you got to share the screen, silly Willy. Here we go. Okay. Oh, come on. What are you doing? Oh, it's not wanting. Oh boy. No, no, no. You don't want to do that. No, no, no. Here. Let me see if I can make it stop doing that. Oh, don't do that. No. All right. Just let it. It's going to actually act stupid for just a minute. I need to close. See, it's not responding. Oh boy. Okay. Well, we're just going to sit here a minute. I'll just keep talking because I need to figure out why is it not responding. I can see some kind of weird. I'm telling you, ever since my husband switched around some of this internet thing, we've had issues with this internet. And it looks like that's what it's trying to do again right now. Let me pull it up over here on YouTube and see what it looks like from my side. So I can, oh, there it goes. Come on. Okay. There we go. Okay, there we are. I think we're fixed now. Okay, there we go. Share. That took care of that. Yay. No, no, don't do that. All right, good. Now, are we fixed? Let's make sure that looks right. Oh my Lord. All right. Now let's go over here. I want to make sure that I'm working okay. Okay. I want to make sure we have sound. I want to make sure everything's working properly as we talk. And it looks like it is, so that is a good sign. There we go. Okay. It looks like I don't see the same thing here that I see there. That's a little bit strange. Okay, now we're fixed. All right. Let me turn this all the way down. Okay, now we can continue on. So let's talk about the Writ Certiorari. Okay, I'm going to get rid of this. And we're going to pull this up. Let's get rid of that over there. And we're going to pull this up over here, which is the Writ Certiorari, and how this is going to be structured and what's going to happen in the state of Colorado. So here we go. Okay. Or state filed. There we go. Okay, we have this pulled up right now. It's thinking about it. It's thinking about it. I hope everybody's having a wonderful day. Here we go. Okay, now this is a case that we're going to talk about. We're going to talk about a case where this has happened before. This is not new. It's happened before, and this is the case they're probably going to have in their writ when they start discussing this. Okay, maybe I'll show it this way. Okay, here's the case: Pena Rodriguez versus Colorado in 2017, and this is in the U.S. Supreme Court. Who? Well, that's the defendant. No, I want to find the other way around where the state files it. Okay. Ooh, they haven't done it in Colorado, but they have done it in other states. Hang on a second. Let me pull this up over here. It's over here. I forgot to save it on this one, not that one. Okay. Here we go. Let me go to my drive. For some reason, my Google Drive does not work on my laptop, but it does on my phone, which I think is the strangest thing. Okay. Here we go. All right. Recents. So there have been cases where this has happened before. And we're going to talk about that right now. And the case that we're going to talk about is, hold on, Riviera versus Illinois. So let's pull up that case instead. Okay. Okay, I'm going to pull it up over here. So Riviera versus Illinois. Jury bias. State filed the writ. Okay, here we go. Okay. Well, it's saying that that's not the right one. Now Riviera tried to use virtual challenge and move the Dolores. Okay, let's see which one it is. Okay. Okay, that is, I am asking the other way around. Hang on a minute. Or state filed the writ. That's not the right one. It is not very often that this happens, but it has happened before. So that's why we want to talk about it. Oh my goodness. Okay, so here's the exact case I'm looking for. Now, it's an old case and it is from 1992, but it is important because it is a situation where there was exactly jury bias. So maybe I should show this one instead. Let's unshare that screen and we'll share the screen that we're actually talking about right now. And then we'll go back to look at it. Okay, here we go. But the case is actually called, let me make sure it's showing up correctly for you guys. Oh, share the screen, silly girl. It's not sharing. Uh-oh. Share. Now, all right, this will take care of that. Now, you should be able to see the same thing I'm seeing. Okay, it's called Morgan versus Illinois, and this meets the criteria that we're talking about. So let's go ahead and look at it really fast. Okay, the state filed the writ. Yes, the state of Illinois petitioned the U.S. Supreme Court after the Illinois Supreme Court ruled in favor of the defense on a jury bias grounds, which is exactly what happened in Letitia Stauch's case. The issue was actual juror bias. The question was whether a juror would automatically vote for the death penalty was biased and therefore disqualified. Now we know that in this case the jury bias was because of um, a person that worked in the district attorney's office being a relative to somebody who was on the jury, which it's kind of different, but it's the same because it's jury bias. No matter which type of jury bias this is, it's jury bias. Okay, and that's what's important about this. So let me pull this up over here. Okay. Um, oh boy, I want to be able to read it from over here, but show you from over there. That's why I'm going to pull it up this way. So it's Morgan versus Illinois. Okay. Okay. Here we go. All right. Okay. Here we go. Now. All right. The U.S. Supreme Court overturned the lower court, and the Scottish held that a defendant has a constitutional right to ask whether a juror would automatically impose death. If such a juror is seated in the trial, it's unconstitutional. The structural error, never harmless. So this is why it's talking about, because there are cases where it has been, when it's went back before the Supreme Court after the state has filed its writ of certiorari, and the state was able to overturn, I know it's crazy, overturn the Supreme Court's ruling and put it back to being affirmed, their conviction being affirmed. And this is what's probably going to happen in the state of Colorado, because the one thing they don't want to do is spend the money to retry Letitia Stauch. Number one, when you do that, if they retry her instead of filing this writ, which they do have a possibility of winning, it is slim, but they do have the possibility of winning it. If they retry her, you are going to um, re-victimize the parents. You have to worry about Harley. You've got to worry about Landon. You have to worry about Al. It's all of them having to live through this again, watching this crazy witch sit over there and act like she is has DID when we know she does not. She actually, look, she pled guilty by reason of insanity. So really, the jury was all about finding whether she was sane or not. And so they bring in all the experts. And the only person that could say she had any type of DID was Lewis, Dr. Lewis. Now we kind of know in these situations we end up with paid expert witnesses that play by what you pay. What I mean by that, if they are working for the defense, they are going to find ways that the defense's story holds. If they're working for the prosecutor, they are going to find ways that the prosecutor's story holds. That's what I'm saying when I say pay to play expert witnesses. They are not all like that, but there are some that are like that. So just know ahead of time that that is a possibility. And I believe in the Stauch case, that was what happened here. You could tell. Let me play this over here right quick, and we'll put this over here in a different section. We'll put let me put this in a different area so we can pull it back up. Why? Okay, so let's talk about why this matters really quick. The exact rule quoted in Love versus Texas. Okay, so there's another case, and it's called Love versus Texas, that the state is disentitled to execute the sentence, citing Morgan versus Illinois. So see, this case has been used in a lot of different cases when they've had to worry about biased jurors. So I'm going to pull this back up this way, and we're going to look at one thing and talk about the other one. Okay, so why does Morgan versus, hang on, got my spot here, versus Illinois work with, hang on, Stauch and Murdaugh. All right, just give me a second to pull this up on this way. That way we can show them both at the same time and talk about it all at the same time. Okay, come on now. Okay. Okay, so we'll copy that. All right, now let me put this over here in our little, we have a little notes section, so I can put this in the notes, put it right there, and we'll paste that. And then we'll pull this back up over here, and we're going to share the screen for the actual Letitia Stauch bullshit. Okay, now, well, hello, stupid, you got to share the screen. I know, y'all, I know. We'll get it going now. Okay. Now, I realize the problem is not the DID. I realize the problem is the biased jury in Stauch. I understand that. But I think it's important that we show a few of the things that happened in this case. How Letitia acted, how the defense acted, how the prosecutors acted. And here's the thing. I know that this is kind of Judge Warner's fault, but I don't care. I still love him, and I still think he is a good judge. I think that this problem is something he did not expect to happen. Okay, so let's go ahead and start talking about Morgan versus Illinois from 1992. Now, this was a high profile case, this works in high profile cases like those of Letitia Stauch and Alex Murdaugh because it establishes a reverse, which is Witherspoon, questioning during jury selection or voir dire. Now, I also am going to pull up, let me tell you what a writ of Certiorari actually is, in case you don't know. And it can be filed by the state or by the defense, either way. Okay. 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 Oh, you got to spell it right. Oh, Lord. Okay. Now then. A writ of Certiorari is a formal and binding order that's issued by a higher court directing a lower court to send up the entire official record of a case for appellate review. So that is what they're asking to happen. It is derived from the law Latin meaning to be more fully informed. It serves as the primary mechanism through which discretionary appellate courts choose which cases that they will look at or they will hear. The key features of this writ is discretionary review. Unlike standard appeals, a higher court is under no legal obligation to grant certiorari. So they can say, no, we're not interested. We're not going to look at it. We don't care. We've overturned it. That's it. You're having a new trial. That is a real possibility in both cases. Okay. The court rejects the vast majority of these petitions. They are not very often that they are granted. The Supreme Court framework. It is most famously utilized by the Supreme Court of the United States, which is SCOTUS. Litigants must file a formal petition for writ of certiorari to request a hearing. That is just to get the hearing. Okay. There is something called the Rule of Four. Now, the Rule of Four is very important when you're talking about a writ of certiorari, or the writ of certiorari. The SCOTUS will only grant the writ and hear the case if at least 4 of the 9 justices vote in favor of doing so. There's selective thresholds. The higher courts typically grant certiorari only if the case holds deep national significance, resolves conflicting decisions across lower federal circuit courts, or addresses a crucial constitutional question. I believe in this case it does answer a crucial constitutional question. Now, then there's the effect of the denial, which most of the time it is denied. If the writ is denied, often abbreviated as cert denied, the lower court's ruling stands as the final legal outcome for the specific case. It does not mean the higher court agrees with the ruling. It simply means they decline to review it. And that happens frequently. Just know that ahead of time. Let's go here and look at this right quick while we talk about it. Okay. Let's see if there's something over here from the actual Westlaw Institute or the Cornell School of Law. I'm looking at their library about the writs to find other information that may help us as we look at this. Okay. Let's see if there's anything different that it says. It says that it has the rule of four that the justice have to agree to review the case. The court will hear the case. This is referred to as granting certiorari, often abbreviated as cert. If four or more justices do not agree to review the case, then the court will not hear the case. This is referred to as denying the cert. Okay. The U.S. Supreme Court will grant the petition for a writ of certiorari to cases that have national significance. Presidential values that harmonize a different ruling in the federal and state courts. The court typically accepts only 100 to 150 cases out of the more than 7,000. That's right, 7,000 writs are filed every year. The cases usually come from an appropriate U.S. Court of Appeals or the higher court in the state in limited situations. Some of the considerations are outlined under the Rule 10 of the Supreme Court. So let's look at, we have the Rule 4 and we have the Rule 10. Okay. There are four primary types of appropriate and effective petitions for writ of certiorari. The first type is a direct appeal in a federal criminal case. And if a defendant is dissatisfied with a ruling from a district court, they may petition the Court of Appeals for review. If they are still dissatisfied with the ruling, they may request the U.S. Supreme Court review their case. There is a second type. It is petition of the state's higher court after denial by a lower court. Okay, like the federal system, most states have a similar system that allows someone charged with a crime to appeal an appellate court. They may then submit a petition for writ of certiorari to the state's highest court if they are dissatisfied with the outcome in the appellate courts. And then here's the third type of writ. This highest state it's called the highest state court in a state's criminal case. In this case, even if the case does not start in a federal court, the defendant can petition for a writ of certiorari for an opportunity for the U.S. Supreme Court to hear the case. This also provides an extra opportunity for the defendant that has exhausted all state judicial procedures to once again review the case. That would be kind of like their final opportunity. The fourth type of petition after writ is a writ of habeas corpus, which you always find that people on death row will file a writ of habeas, a certiorari for a habeas corpus to the appeals court. And if a district court denies the defendant's writ of habeas corpus, the defendant does not have an automatic right to appeal to the U.S. Circuit Courts. Rather, they must first file a request for certificate of appealability from the district court that heard the writ. If denied, they must file a certificate of appealability from the circuit court before filing the writ with the circuit court. It's a lot of legal maneuvers in order for people to change what the outcome is. Okay, now let's also talk about, let me pull this back up over here. Now I need to find my, okay, now go ahead and find Stauch. I have all my stuff over here on Stauch on the phone. Here we go. Let me pull this up right quick. Okay. Now let's talk about the actual Stauch retrial if it's going to happen in Colorado. Now, we know that on April the 2nd, 2026, the Colorado Court of Appeals overturned the murder conviction of Letitia Stauch, who was found guilty in 2023 of killing her 11-year-old stepson, Gannon. This happened in El Paso County. The three-judge panel vacated her conviction and ordered a new trial, not because of new evidence, not because of the verdict. It was because one juror should never have been allowed to deliberate. This case has drawn national attention since Gannon disappeared from his Colorado Springs home in January of 2020. His body was found weeks later in Florida, and Letitia Stauch was convicted of first-degree murder and related charges after a 5-week trial and sentenced to life in prison without the possibility of parole. Now, none of that mattered to the Court of Appeals. None of that mattered. What mattered here, again, was this one juror. During voir dire, the questioning process used to select and evaluate prospective jurors, a prospective juror identified as Juror MB disclosed that his son-in-law worked as a deputy district attorney in the El Paso County District Attorney's Office, the same office prosecuting the case under District Attorney Michael Allen. Defense counsel challenged Juror MB for cause, because, for cause, and the district, I lost my place. The district court judge Gregory Werner declined to remove the juror. Juror MB went on to deliberate and was part of the jury that convicted to Letitia Stauch. Now, the statutes that the trial court ignored, we're going to talk about all of it because it's important. I don't want this retried. There are a lot of us who do not want this retried for the same reason, because of what it's going to do to the family. There's also the cost involved. And here, I don't know if any of y'all remember this, but there was phone calls from prison that some of our friends were actually able to secure. And in those phone calls from prison, I remember hearing Letitia talk about this appeal. She always was so sure she was going to get this appeal. And that's another reason why it kind of makes me so angry that this happened, because I did not want her to win this appeal, period. I do not want to see her win anything. She took that baby's life. She knew what she was doing. And we're going to talk about that again in just a second. But let's look at the statutes in the trial court. Colorado Revised Statute 16-10103 sets out that the grounds on which a court must sustain a challenge for cause for prospective jurors. The statute uses mandatory language. When any of the listed grounds are present, the court shall grant the challenge. This is no judicial discretion. It's once this is triggered circumstances, it's established. So it was triggered, it was established, and they did call that to Judge Werner's attention. Subsection 1B of the state covers jurors related with the third degree to a certain participants in the case. In People versus McRander, the Colorado Supreme Court interpreted this provision to include not just the elected district attorney, but any deputy district attorney in the prosecuting office at the time of jury selection. A son-in-law, his relationship is third-degree relationship under Colorado law. Juror MB fell squarely within the category that the statute was designed to exclude. So absolutely, he should have been excluded. The Court of Appeals opinion, written by Judge Nieti Parr, in case number 23 CA 1067, focused on what trial court said when it refused to remove juror MB, that the juror's connection to the DA's office did not rise to statutory cause. The appellate's court found that reasoning legally was incorrect. Under 16-10-103, a family relationship like MB to deputy district attorney in the prosecuting's office, it matters, right? And you can't just be discretionary. It mattered. He should have been removed, period. It's right there in the statutes. But rather than a mandatory grounds for removal, the trial court did not have the option to weigh the relationship and decide it was close enough to be fine, because there's no way it could be fine. The statute says no. So they ignored the statute. Basically, the statute was ignored. Now, here's something I want to go out and look at. I want to go pull up this case right here, which is People versus McRander out of Colorado, which is directly the same type of a case. So let's pull this up over here. Bear with me. Okay. Miranda, how do you spell this? Let's make sure we spell this name right. MacRander versus Colorado. Okay, let's see. All right. Okay, so in this particular case, all right, let me share the screen on this part, and we'll come back to this. We'll come back to Letitia Stauch and Mrs. Lewis, Dr. Lewis. Here we go. Let's talk about this one over here. Okay, share. Now, make sure you see what I see. Make sure it's okay, showing correctly. So this is the case that we're going to talk about, which People versus, hang on a minute. People versus McCrander, Colorado Supreme Court in 1992, and it was about a jury bias situation. Under citation 828P.2D 234, Colorado 1992. The Colorado Supreme Court case involving jury selection error, but not jury bias in the constitutional sense it is about. A juror whose son was deputy district attorney in the same office prosecuting the case. This is the kind of the differences. The defense challenged her for cause. The trial court wrongly denied the challenge, and the defendant had to use his premonitory strikes to remove and then round out of premonitories. Now let's pull this up right here. We're going to look at this case at Justa. Okay. Now, in People versus McCrander, let me make sure y'all see the same thing I do. Okay, you do. Very good. So I can read it. In People versus McCrander, 817 P2D 579, Colorado AP 1991, the Court of Appeals decided two questions concerning jury selection in a criminal prosecution. The court held that the prospective juror whose son was a deputy district attorney on the staff of the elected district attorney who initiated the prosecution was subject to the challenge for cause under Section 1610-103 as being related within the third degree to any attorney of record. The court also held that the trial court's denial of the defendant's challenge for cause was prejudicial error requiring a new trial under the circumstances where the defendant removed the suspect juror by preemptory challenge and exhausted all available preemptory challenges on other jurors. We granted Certiorari to review the decision of the Court of Appeals, and we now affirm the judgment. Okay, so here we go. The defendant, Leo Jason McCrander, was charged in a felony complaint filed in the County Court of Jefferson County with, and it's got a star 237, attempted second-degree murder, first-degree assault on a peace officer, and felony menacing, and 2 counts of committing a crime of violence, all which allegedly occurred on May 28th of 1988. The complaint began by stating that Donald E. Milkey, District Attorney, and for the First Judicial District of the State of Colorado, in the name of the authority of the People versus State of Colorado, informs the court and then set forth 5 separate felony counts. The complaint was signed in the following manner. Donald E. Milkey, District Attorney, James D. Anderson, Deputy District Attorney, registration number 13121. The defendant waived his right to preliminary hearings, and the case was bound over for trial to the District Court of the First Judicial District. On May 16th of 1989, jury selection commenced in the District Court. During the trial court's general questioning of the entire jury panel, one of the prospective jurors, Catherine McNulty, stated that her son is a Deputy District Attorney for this district. When Ms. McNulty was later called into the jury box for further questioning on voir dire, the following exchange occurred between her and the prosecuting attorney, James Stanley. Now, let me get this right here for a second. This sounds exactly what happened with Letitia Stauch's case. Exactly. We'll keep going. Mrs. Stanley, they're asking her questions in the voir dire. This is what's happening. Mrs. Stanley, Mr. Stanley, now, Mrs. McNulty, of course you present a special situation for everyone here. Being that I work with your son, Juror McNulty says, yes. Mr. Stanley, I don't work with him, but he's in our office. Do you know me? Have you ever seen me before? Juror McNulty says, no. Mr. Stanley, well, your son doesn't discuss anything about his work. Juror McNulty says, no, he doesn't. Mr. Stanley, well, as you know, and as you recognize immediately, of course, it's a concern that your son is a district attorney, and that the obvious question is, how do you feel about it? Do you think you could be completely fair if you were on this jury? Juror McNulty, I think so. Mr. Stanley, I mean, for instance, whatever your decision is when you go back and see him, well, of course you don't live with your son. So she didn't live with her son. She says she's not going to talk to him about this. Juror McNulty, no, he's married. And then Mr. Stanley says, do you see him much? Juror McNulty says, yes, he's over quite a bit. Mr. Stanley says, I suppose one thought that we were all having is that you might feel pressure to lean towards the prosecution because of your son's occupation. Do you feel that way at all? And Juror McNulty says, I don't think so. The defense counsel then starts asking questions of Ms. McNulty. Defense counsel, during his voir dire of the prospective jurors, challenged Mrs. McNulty for cause pursuant to Section 1610-103 on the grounds that her son was a deputy district attorney on the staff of the district attorney's office, which initiated the prosecution, and that the district attorney's office was the attorney of record in the case. The prosecuting attorney objected to the defense counsel's challenge for cause, and the trial court denied the challenge. This is exactly what happened in Letitia Stauch's case. This is exactly the same scenario. The trial court ruled that because Mrs. McNulty's son was not involved in the particular case being tried, her son was not an attorney of record within the meaning, and that the term in the section 1610-103. Defense counsel thereafter used a peremptory challenge to remove Ms. McNulty and exhausted all 5 of his peremptory challenges authorized by section 1610-104. At the conclusion of the voir dire, the court swore that the impaneled jurors for trial, which was, it says there's a number 5 there. Anyway, the jury ultimately returned a guilty, and then a guilty verdicts on all counts, and the court imposed the concurrent sentences with a maximum term of 32 years. The defendant appealed the Court of Appeals, which reversed the judgment of conviction and remanded the case for a new trial. The Court of Appeals reasons that each member of the staff of the district attorneys who is charged by law with prosecuting a particular case must be considered to be an attorney of record. Meaning, this is what this means. Okay, I'm putting the whole thing right there. What this means is it doesn't matter whether you're the prosecuting attorney or you're chair number 5 and you're in a different courtroom on a completely different case. You're all attorneys of records because you all work for the same county or the same district attorney's office. Okay, that is what they're saying here. Now, in those cases being prosecuted in the name of that district attorney, at least for the purposes of the particular statute under consideration here. McCrander, 817 P2D at 582, which is the book this is in. In addition, the Court of Appeals held that whereas here, the trial court erroneously denies a challenge for cause and the defendant uses all his peremptory challenges, including one to remove the disqualified juror. The trial court's denial of this challenge for cause must be viewed as prejudicial error because its effect is to deprive the defendant of his guaranteed number of peremptory challenges. We granted the people's petition for Certiorari to consider whether the term attorney of record in section 1610-103 includes all deputy district attorneys on staff of the district attorney's office responsible for the prosecution of the case then being tried, including those deputies who have had no involvement in the case, and also whether prejudicial error occurs when a trial court erroneously denies a challenge for cause and the defendant thereafter uses peremptory challenges to remove the suspect juror not removed for cause and exhaust all available peremptory challenges. Number 2, we first addressed the meaning of the term attorney of record. In section 16-10-103, the people argue that the term refers only to those prosecuting attorneys who have had some direct involvement in the case by signing a charging document or other pleadings, or by appearing in court on behalf of the people at some stage of the prosecution. Our resolution of the people's claim proceeds from the consideration of the purpose served by the challenge for cause in a criminal case and the nature and scope of the statutory authority vested in the elected district attorney and members of the district attorney's prosecuting staff. Now we're going to go to A. A fair trial and a fair tribunal is basic requirements of due process. And Murchison, there's where it's stated, fairness requires more than the elimination of actual prejudice. It has been cogently observed that if justice is to perform its high function in the best way, it not only must achieve the reality of fairness, but must satisfy the appearance of justice as well. To that end, the right to challenge a juror for cause has been recognized as an integral part of a fair trial. The bias of the prospective juror may be actual or implied. That is, it may be biased in the fact or bias conclusively presumed as a matter of law. In the United States versus Wood, actual bias is a state of mind that prevents a juror from deciding the case impartially and without prejudice to a substantial right of one of the parties. Black's Law Dictionary in 162, in the 6th edition, implied that bias is a bias attributable in law to the prospective juror regardless of actual partiality. In Wood 299 in the U.S. at 134, bias may be implied, for example, when a prospective juror has a close relationship to a party or attorney in the case, or has had an important contact with the case, so as to create serious doubt about the prospective juror's impartiality, if not in fact, that at least in appearance, people in the interest of RAD, Colorado, blah. Okay, then it goes down to section 2, is number 239, section 1610-103. Lists 11 separate grounds for challenging a prospective juror for cause and states that the court shall sustain a challenge for cause predicated on any one of them. Those grounds include not only a demonstrable showing of the prospective juror's actual bias, but extend to various forms of implied bias, as well as including specific relationships between a prospective juror and the interested parties or participant in the case, and particular experiences which might impair a prospective juror's ability to maintain a genuine state of impartiality throughout the trial. Included with these 11 grounds is the prospective juror's relationship with the third degree by blood, adoption, or marriage, to an attorney of record or attorney engaged in the trial of the case. Okay, so in section 16-10103, evinces a realistic legislature judgment that a prospective juror's close familial relationship to an attorney of record could engender such subtle forms of pressure on the juror's sense of impartiality as to constitute a bias implied by law without regard to a demonstration of actual bias. We have accorded a trial court considerable discretion in rulings on casual challenges predicated on actual biases, primarily because such challenges require an assessment of the prospective juror's credibility, demeanor, and sincerity in explaining his or her state of mind, and because the trial court is in a preferred position to evaluate those factors. Okay, and it talks about People versus Abbott, People versus Riot, People versus McCrae. There's several of these. A challenge for cause predicated on section 1610-103, however, involves a narrow inquiry into the objective and readily determinable relationship between the prospective juror and an attorney of record. If the statutory relationship is established and a party challenges the prospective juror for cause, on that ground, the trial court has no discretion in the matter and shall sustain the challenge by removing the juror from further service on the case. B. The Colorado Constitution states that in each judicial district there shall be a district attorney elected by the electors thereof. Colorado Constitution, there. Although the district attorney is an officer of the court as any other attorney, the district attorney is a member of the executive department, People versus District, and that the capacity is expressly authorized by statute to appear on behalf of the people in all criminal cases for crimes committed within the geographical boundaries of the judicial district served by the district attorney. And it's People versus Taylor is another one. One of the statutory requirements of a criminal prosecution, whether initiated by indictment or information, is that it be signed by the person authorized by law to prosecute the offense, namely the district attorney or judicial district in which he alleged the crime was committed. Oh boy. The elected district attorney is authorized to appoint not only an assistant and chief deputy district attorney, but also such deputy district attorneys as he deems necessary to properly discharge the duties of his office. Assistant, chief deputy, and deputy district attorneys must be admitted to practice law in the state of Colorado, serve at the pleasure of the district attorney, and have all the powers of the district attorney. The design of this statutory scheme is to reciprocally vest prosecutorial authority in the elected district attorney and all members of the district attorney's staff, the assistant, the chief deputy, and the deputy district attorneys that an act performed by the district attorney is an act undertaken on behalf of all members of the district attorney's prosecuting staff in the same manner and to the same extent as the act performed by the assistant, the chief deputy, or deputy district attorney is act undertaken on behalf of the elected district attorney. So I think this makes, to me, it makes a lot of sense because what they're saying is, listen, even if you're not on this case, any other case, you have the same powers as the elected district attorney. You can do the same job he is doing because he's appointed you to be on his staff to do the same job he would be doing. But for whatever reason, the elected district attorney is the prosecuting attorney in the case that we're talking about. Okay, so here we go. Let's go back and finish. It's a lot to read, but I think it's pretty important and it'll help us understand why the state needs to file the cert first. All right. The purpose of the challenge for cause and the nature of the agency relationship existing between a district attorney and the members of the district attorney's prosecuting staff provide the analytical framework for our constitution of the term attorney of record. In section 1610-103, the term attorney of record is commonly understood to refer to lawyers who formally appear in the court for the purpose of representing a party in a judicial proceeding. This commonly understood meaning is not substantially different from the technical sense of the term, which is an attorney who has formally entered into the case on behalf of a party by filing a written entry of appearance or by informing the court on record of the attorney's entry into the case. See Black's Law Dictionary, anyway, the 6th edition. Defining an attorney of record as an attorney who has filed a notice of appearance and hence is formally mentioned in court records as the official attorney of the party. Attorney is of record when attorney appears personally before the court, files a written entry of appearance, or has been appointed by the court. Attorney desiring to enter appearance, other than attorney initially appearing on behalf of the party, in the first instance must file a written entry of appearance or obtain court order recognizing the attorney's appearance. No attorney shall appear in any matter until the attorney files a written entry of appearance. Okay. Both the commonly accepted and technical meanings of the term attorney of record leave no doubt that the elected district attorney of a judicial district who initiates a criminal prosecution is clearly an attorney of record. For purposes of section 1610-103, we are also convinced that in light of the need to eliminate the more subtle forms of bias stemming from a prospective juror's relationship to an interested party or participant in the case, and the term attorney of record in section 1610-103 should be construed to include any deputy district attorney serving in the office of the district attorney at the time of voir dire examinations, even though the deputy district attorney may not have formally appeared or participated in the case. That construction, we believe, furthers the object sought to be achieved by the challenge for cause and is consistent with the legislature's decision to vest reciprocal prosecutorial authority in the elected district attorney and members of the district attorney's prosecuting staff. We have recognized in other contexts that all-inclusive and reciprocal agency relationships existing between a district attorney and members of the district attorney's prosecuting staff. Pease versus the district court is one. There's an ethical rule of imputed disqualification, which requires private law firms to withdraw when another lawyer in the firm is to be called as a witness on a contested issue. Applicable to entire district attorney's offices when a deputy district attorney endorsed as a prosecution witness. Okay, People versus Garcia. Okay, People versus Castro. There's been a bunch of those. An assistant and a deputy district attorney function by virtue of the district attorney's authority and acts as an assistant or deputy district attorneys are done in the name of the district attorney. Let's see. We would substantially depreciate the role of assigned the challenge for cause in a criminal case were we now to hold that, notwithstanding the pervasiveness of the agency relationship between an elected district attorney and members of the district attorney's office or the prosecuting staff. Only those deputy district attorneys who formally appeared or participated in the case qualified as attorneys of record for the purpose of this section 1610-103. We cannot ignore the practical consequences of the construction urged by the people. which would limit an attorney of record to a deputy district attorney who formally appeared or participated at some stage of the criminal prosecution. Under that construction, a deputy district attorney who conducted lengthy investigations of the case and recommended the filing of criminal charges against the defendant, or who undertook significant legal research on critical issues involved in the prosecution, would lack the direct and formal involvement in the case essential to challenge for cause, despite the fact that the deputy district attorney well might have a much greater interest in the outcome of the case than a deputy who formally appeared on behalf of the people at an arraignment or some other routine phase of the criminal prosecution. A mother, a father, a wife, or a husband of the deputy district attorney who's investigated the case or researched legal issues would not be challengeable for cause under the people's proposed construction, while the same relatives of a deputy district attorney whose only role in the case consisted of appearing at a routine arraignment would be subject to challenge for cause. The consequences of the people's proposed construction, in our view, would compromise the appearance, if not the reality, of the fairness in a criminal prosecution and would weaken to a significant degree public trust and confidence in a criminal justice system. We hold, therefore, that a prospective juror who is related within the third degree by blood, adoption, or marriage to a deputy district attorney presently serving on the staff of an elected district attorney responsible for the criminal prosecution is related to an attorney of record for the purpose of the challenge for cause under Section 1610-103. In the instant case, the 5-count criminal complaint was initiated by Donald E. Milkey, District Attorney, and in and for the Judicial District of the State of Colorado in the name and by the authority of the people versus the state, of the people of the state of Colorado, and was signed by Deputy District Attorney acting for and on behalf of the District Attorney. By so initiating criminal prosecution, the District Attorney entered an appearance not only in his own name, but on behalf of his prosecutorial staff, including the Assistant District Attorney, the Chief Deputy District Attorney, and all Deputy District Attorneys. It follows, therefore, that each Deputy District Attorney on the district attorney staff was, at the commencement of the voir dire, an attorney of record for the purposes of challenge for cause made pursuant to Section 1610. The trial court accordingly erred in denying the defendant's challenge for cause and directed to Ms. McNulty, who unequivocally acknowledged that she was the mother of a deputy district attorney, then serving on the staff of the elected district attorney, Donald G. Milkey. We turn now to consider the effect of the trial court's erroneous ruling on the challenge for cause. The people argue that the trial court's ruling, even if erroneous, does not constitute reversible error unless a defendant demonstrates that the ruling resulted in a biased jury. A resolution of the people's argument requires a consideration of the role played by the preemptory challenge in the criminal trial. Okay. Then we're going to go back to A. Hang on a second, guys. Now, I know it's a lot to read, and I know it kind of sounds a little bit, boring, but it's not. I mean, we just need to get through it because it is exactly what we saw, what we've seen. Okay. Best you. Okay, listen, don't come in here. We're not going to allow this. I'm going to hide that because I don't want you advertising something else in my chat. So let's just not do that. I'm going to remove Twitch from here because I don't want to put up with that again today. Sorry about that. We're going to take it off of Twitch. There we go. Remove. There we go. Now we don't have to worry about that now. Okay. Save the changes. All right. Now we can go on and we won't be seeing this anymore. All right. Now, here we go. Yeah, I don't want people coming in here off of Twitch advertising something else. You either want to come and participate in our chat and talk about what we're talking about, which is a very, very important subject for the retrying of Letitia Stauch. Okay, here we go. The preemptory challenge serves for the purpose of providing both the defense and the prosecution with a greater opportunity to secure a balanced and impartial jury by rejecting a limited number of prospective jurors without cause. The ABA Standards for Criminal Justice, Trial by Jury, number 15-2.6, although the preemptory challenge by its very nature will often be exercised for reasons personal to the challenger, the opportunity to exercise the challenge has been described as one of the most important rights secured in an accused, the erroneous deprivation of which must be condemned. Pointer versus the United States. There's a few more of those. Let's see. recognizes that the significant role played by the peremptory challenge in a criminal cause and states that where there is one defendant and the punishment may be imprisonment in the correctional facilities operated by the Department of Corrections, the state and the defendant shall each be entitled to 5 peremptory challenges. Approximately 80 years ago, this court in Denver City Tramway, Colorado versus Kennedy, a civil case, rejected the proposition that a trial court's erroneous denial of a challenge for cause results in reversible error only if the challenging party, who in that case exhausted all peremptory challenges, demonstrates that some other objectionable juror who was permitted to serve on the jury by reason of the trial court's erroneous ruling. The Kennedy court reasoned as follows. So this was a long time ago, but it still counts because it's another case that they can state, well, this is what happened in that case. This goes all the way back to 1911. It's pretty interesting. Okay. It could be just as consistently argued that a judgment should not be reversed where the court had limited the number of peremptory challenges to less than the number allowed by law, unless the complaining party could show some further injury occasioned to him, thereby which could not usually be done in a case like the one under consideration. Here, a right given to the defendant by the statute was denied. The injury complained of was the denial of the statutory rights. That is the error that the court committed, and that is injury complained of. They did complain about it. They did talk about it. He did want to remove them. The result of which compelled the defendant to exhaust one last peremptory challenge to be used upon others. Had the objection been sustained, the personnel of the jury would have been different. As to what effect this might or might not have upon the ultimate result of the trial is a matter of pure conjecture, and is not for the trial court or even this court to make a guess. When a privilege which the legislature has seen fit to give a party litigant has been denied him and is properly complained of on review, and this court ascertains that such right was denied him, it has performed its duty. To go any further would be to add to the statute a matter which the legislature did not deem proper to incorporate in it, and is to undertake judicial legislation which the court should be exceedingly careful to avoid. The reasoning of Kennedy is unassailable and applies. Okay. The reasoning of Kennedy is unassailable and applies with even greater force to a felony prosecution where the stakes are considerably higher than those in an ordinary civil case. Indeed, this court acknowledges that the soundness of Kennedy's reasoning in Harris versus People, and that was from 1945, a criminal case, but concluded that the trial court's erroneous ruling on the challenge for cause was harmless because the defendant did not use a peremptory challenge to remove the suspect juror. Most recently, in 1978, we decided in the interest of RAD, in which we reversed an injunction of juvenile delinquency under the circumstances very similar to those present here. In that case, the trial court denied the juvenile's casual challenge to a security guard employed by the state of Colorado at the Colorado Bureau of Investigations. The juvenile then excused the suspect juror to peremptory challenges and exhausted all other peremptory challenges. We held that the trial court erred in not excusing the challenged juror for cause as a compensated employee of the public law enforcement agency pursuant to Section 24, 8A, and that was from 1986, and that the trial court's error could not be deemed harmless. Okay. The appellant was deprived of his statutorily guaranteed number of peremptory challenges, for he was forced to employ one of them to excuse a juror who should have been excused for cause. Had that challenge been sustained, the composition of the jury would have been different. No one can tell what effect this might have or had upon the trial's outcome, and is not for us to speculate. Okay, we followed the same approach in Naylor versus People, in which we somewhat similarly reversed a criminal conviction under the circumstances where the trial court erroneously denied a challenge for cause, and the defendant thereafter removed the suspect juror and exhausted all peremptory challenges. Naylor was followed and applied in Morgan versus People, in reaching the same result. The rationale of these cases is when a defendant is forced to utilize a peremptory challenge to correct a trial court's error in denying a challenge for cause, and thereafter exercises all available peremptory challenges on other prospective jurors, the effect of the trial court's erroneous rulings on the challenge for cause is to impair the defendant's ability to change the ultimate composition of the jury selected to try the case, We hold, therefore, that the trial court's erroneous ruling on challenge for cause, which is followed by the defendant's use of a peremptory challenge to remove the suspect juror and the defendant's exhaustion of all available challenges, affects the substantial right of one the defendants and cannot be deemed as harmless errors. Oh, see, this is why it's kind of looking bad, and it makes me think even if they file this writ, they may not have a chance in hell. I'm just going to say it. They probably won't have a chance in hell, but I would still file the writ if I was the DA. I would file the writ and at least try it. We acknowledge some tension between our rejection of harmless errors analysis and our decision in People versus Cibola. In Cibola, this court approved the following two-part test for appellate review of the trial court's erroneous ruling on the defendant's challenge for cause. Did the defendant exercise all the peremptory challenges? And number two, was the defendant deprived of the right to challenge other prospective jurors because he was forced to exhaust his peremptory challenges to excuse the other suspect juror? The court, however, declined to rule on whether the trial court erred in denying the challenge for cause because the defendant, although having exhausted all available peremptory challenges, including one directed to the suspect juror, failed to allege or show that the second factor existed in this case. An analysis of Cibola's two-part test demonstrates that it is basically flawed. If Cibolo is read to require a defendant to allege or show that some other juror, in addition to the suspect juror, was permitted to serve on the jury but should have been removed for cause, it would result in imposing an extremely onerous, if not impossible, burden on a defendant because the impaneled jurors already would have been passed for cause or would have survived a prior unsuccessful challenge for cause. It would be the rare case, indeed, that a defendant could ever establish that any of the impaneled jurors should have been removed for reason not disclosed during the voir dire examination, or, if disclosed during the voir dire examination and made the bias of the challenge for cause, not deemed by the court as satisfying any statutory criteria for a casual challenge, to the extent that the second part of Cibola can be so read. Cibola is expressly overruled. If, on the other hand, the second part of Cibola test is read required to the defendant's first to identify a prospective juror whom he would remove by an additional peremptory challenge, and then to state the reason why the prospective juror would be removed, then Cibola's test adds nothing of legal significance to the prejudice calculus that was not already established by the defendant's compliance with the first part of the test. There are a number and a variety of considerations that can be entered into the decision to exercise a peremptory challenge against a prospective juror, and many of those considerations may be nothing more than the feelings of or hunches about a prospective juror. In our view, the reasons why a defendant might choose to excuse an impaneled juror by using additional but unavailable peremptory challenges neither mitigate nor aggravate the damage already caused by the defendant's use of a peremptory challenge to remove a juror who should have been excused for cause, and the defendant's exhaustion of all other available challenges on other prospective jurors. A third reading of Cibola is also possible. Cibola possibly might be read to require a defendant to inform the trial court that if additional challenges were to be granted, it would be used against any one of the prospective jurors. This requirement is also without legal significance. Since the number of challenges is set by statute, it is not a matter of the judicial discretion. And then it says, go see Blades versus DeVoe or People versus Fink. The most that the such requirement might do is to provide the trial court with an opportunity to correct its erroneous ruling on the challenge for cause. A trial court, however, has the power to correct prior erroneous rulings upon its own motion, with or without any request to do so by the defendant. As in this case of the prior reading of Cibola, we fail to see how this additional ruling on the challenges for cause, the defendant's use of a peremptory challenge to excuse the suspect juror, and the defendant's exhaustion of all available challenges is authorized by statutes. And here we go. In the instant case, the record demonstrates that the trial court erred in denying the defendant's challenge for cause to one of the prospective jurors, that the defendant was required to exercise a challenge in order to remove the suspect juror, and the defendants exhausted all available challenges on other jurors, and that the defendant was deprived of an important statutory right to use another challenge for other purposes of changing the composition of the jury, ultimately selected to try the case. We are satisfied that the record adequately demonstrates that the defendant was adversely affected by the trial court's erroneous ruling on the challenge for cause, and that the trial court erred and cannot be deemed harmless. Wow. Okay. Now, after a jury is sworn by defense counsel, out of the presence of the jury, requested additional challenges to offset the court's denial of the previous challenge for cause, directed that Ms. McNulty, the court denied defense counsel's request. We do not consider defense counsel's request legally significant to our resolution on the case. And it goes, see generally Blade versus DeVoe. Okay. The court shall sustain a challenge for cause on one or more of the following grounds: absence of any qualification prescribed by statute to render a person competent as a juror, relationship within the third degree by blood, adoption, or marriage to a defendant or to any attorney of record or attorney engaged in trial of the case, standing in the relation of guardian and ward, employer, employee, landlord and tenant, debtor and creditor, a principal and agent, or being a member of the household or a partner in business with or surety on any bond or obligation for the defendant. The juror has or has been a party adverse to the defendant in civil actions or has complained against or been accused by him in criminal prosecutions. The juror has served on the grand jury which returned the indictment or on the coroner's jury which inquired to a death of a person whose death is subject to an indictment or information or any other investigatory body which inquired into the facts of this criminal charge. The juror was a juror at a former trial arising out of the same factual situation or involving the same defendant. The juror was a juror in a civil action against the defendant arising out of the act charged as a crime. The juror was a witness to any matter related to the crime or its prosecution. The juror occupies a fiduciary relationship to the defendant or a person alleged to have been injured by the crime or the person whose complaint the prosecution was instituted. The existence of state of mind in the juror, the existence of the state of mind in the juror evincing enmity or bias towards the defendant or the state. However, no person summoned as a juror shall be disqualified by reason of previously formed or expressed opinion with reference to guilt or innocence of the accused, if the court is satisfied from the examination of the juror or from the evidence that he will render an impartial verdict according to the law and the evidence submitted to the jury at the trial. The juror is a lawyer or a compensated employee of a public law enforcement agency. All right. Criminal P24 tracks the language of Section 1610-103. Our construction of the term attorney of record therefore applies equally to both the statute and the rule. The term third degree describes the degree of relationship between one person and another based on the blood relationship and affinity or relationship by marriage. Each generation is called a degree and determining the particular degree of the relationship. And it goes, see generally 54 and then, go to the books. Okay, descent and distribution among the cousins. That's from 1957. Without exhausting the possible relationship, a prospective juror would be related to an attorney or record within the third degree by blood if the attorney was the juror's child or parent, brother or sister, grandchild or grandparent, niece or nephew, great-grandparent or great-grandchild. Similarly, a prospective juror would be related to an attorney of record within the third degree by marriage if the attorney was the spouse of the prospective juror or if the attorney was the child, sibling, grandchild, grandparent, uncle, aunt, niece, nephew, great-grandchild, or great-grandparent of the spouse of the prospective juror. The mere fact that the prospective juror's relationship with an attorney of record satisfies the bias for challenge for cause does not mean that the juror must be automatically excluded from the service of the case. The design of the statute is to provide both the prosecution and the defense the right either to challenge the prospective juror for cause or to forego the challenge. The people contend that the inclusion of the term attorney engaged in the trial of the case in Section 1610-103 evidences legislature's attempt to exempt only those potential jurors who are related to attorneys with direct and formal involvement in the case. In our view, the term attorney engaged in the trial of the case is self-defining and refers to an attorney who actually participates in the trial before the jury. An attorney engaged in the trial of the case, obviously, would be an attorney of record with the results that any prospective juror related to the attorney within the third degree would be subject to a challenge for cause. The fact that the statutory challenge for cause is cast in alternative terms of any attorney of record or attorney engaged in the trial of the case is entirely consistent with the legislature's intent to include not only prosecuting attorneys on the district attorney's staff, but also defense attorneys who previously entered into an appearance on behalf of the defendant, but who may not be participating in the trial of the case, as well as any attorney who will act on behalf of any party during the trial, regardless of the level of that attorney's participation. The rationale supporting our holding applies also to lawyer members of the State Public Defender's Office. The State Public Defender is required to represent each indigent person who is under arrest or charged with committing a public defense, committing a felony. If the defendant requests such a representation, or if the court is on motion or otherwise appoints the State Public Defender, and the defendant does not affirmatively reject the appointment. Oh, wow. Okay, let's see. Section 21-1-102 authorizes the State Public Defender to employ a Chief Deputy Public Defender, a Deputy State Public Defender, necessary to discharge the functions of the office. In addition to Section 21-102, that requires the state's public defender to establish such regional offices as he deems necessary to carry out the duties under this article. Because the Chief Deputy and Deputy State Public Defense Act, and on behalf of the state's public defender, the Chief Deputy Public and the Deputy Public Defenders would be the attorneys of record for the purpose of Section 1610-103 in cases where the state's public defender office is representing the accused. Number 11. There's a lot of these. I'm sorry, guys. It take a minute to read it, but it's important. It is important. Peremptory challenges, of course, cannot be used to exclude otherwise qualified, unbiased prospective jurors solely by reason of the juror's race. Okay. The people urge us to follow the analysis of Ross versus Oklahoma. In resolving this case, we find that the people's reliance on Ross to be misplaced. In Ross, which involved an Oklahoma capital trial for first-degree murder, the Supreme Court held that the defendant's Sixth Amendment right to an impartial jury was not violated under the circumstances where the trial court erroneously denied the defendant's motion to remove for cause a prospective juror, and the defendant thereafter exercised all available peremptory challenges, including a peremptory challenge to remove the suspect juror. Under Oklahoma law, a trial court's erroneous ruling on a challenge for cause could be asserted as error only if the defendant exercised a peremptory challenge against the suspect juror, exhausted all available peremptory challenges, and further demonstrated that an incompetent juror was forced upon him. In affirming the defendant's conviction and death sentence, the court remarked that had the suspect juror sat on the jury, or had the defendant established that any one of the 12 jurors who served on the case was not impartial, the death sentence would have been overturned. The court, however, found no constitutional violation of the defendant's rights to an impartial jury because the peremptory challenges are not of constitutional dimension. And so long the jury sits impartial, the fact that a defendant had to use a peremptory challenge to achieve the result does not mean the Sixth Amendment right was violated. The issue in Ross, which directly involved the accused's Sixth Amendment rights to impartial juries, requires some showing that the jury ultimately selected to try a case was not impartial. In contrast to Ross, the issue in the instance is not whether the jury selected to try the case was impartial in the constitutional sense of that term, but whether the trial court's erroneous rulings or challenges for cause constituted harmless error or instead affected the substantial right of the defendant. Moreover, the Supreme Court decided in Ross, in the context of Oklahoma law, which required a defendant to show that in addition to removing the suspect juror and exhausting all available challenges, an incompetent juror actually served on the case. For reasons presently discussed in the text, we reject the Oklahoma rule that a defendant must demonstrate that in addition to removing the suspect juror by challenge and exhausting all available challenges on other jurors, that a biased or otherwise incompetent juror was forced upon him. That doesn't make a lot of sense, but okay, we'll go with it. The court in Samala relied on Skeets versus People. For the two-part test in Skeets, this court assumed that the trial court had erred in denying the defendant's challenge for cause, but found no error because the defendant failed to exhaust all of his challenges and did not show that he was deprived of the right to a challenge in any other prospective juror because he was forced to exhaust his challenges to excuse the particular juror who had thus expressed to himself in the form of his opinion about the case. The court in Skeets Skills concluded that there could be no prejudice to the rights of the defendant resulting from the denial of a challenge for cause. In overruling Sabal, we also overruled Skills insofar as Skills might be read to require a defendant to make particular showing that in addition to exhausting all of his challenges and removing the suspect juror by challenge, he was prejudiced by being deprived of the right to challenge some other juror. The prejudice already discussed is the impairment of the defendant's statutory right to change the composition of the jury selected to try the case by reason of being forced to use a peremptory challenge to remove the suspect juror whom the trial court refused to excuse for cause and by using all other available challenges on other jurors. See, this is exactly what happened in Letitia Stauch's case. Right here, we're reading exactly what happened here because Judge Warner did not excuse the juror. He was left on the jury. Let me go here. He was left on the jury. Hey there, Cinderella. Hey, good to see you. I was just reading along, you know. So sorry, I didn't see you were there. Hang on. Yeah, it's unfortunate. Yeah, the judge should have known better. He really should have. I mean, the law is really clear. That's why I'm reading all this because these exactly do. It's the exact same thing that happened in Letitia's case right here, and this is why they were overturned. And I don't know that filing the writ's going to make a difference, but I would still do it. I mean, you have to do everything you can before you start spending hundreds of thousands of dollars, really, hundreds of thousands of dollars to retry Letitia Stauch, right? I mean, it's the same thing with Murdaugh. I know that they're already talking about retrying Murdaugh. I have not seen anything that, well, of course, the ruling just came out today. It was printed today. That I've not seen anything where the attorney's office over there has talked about retrying the case or trying to file a writ. I've only seen, oh, they're in a hurry to get this done again. Well, there's no way to hurry. See, in this, there's no way to hurry. It's going to take a long time. Let me get back to where we were and see if we can get this finished. But hey, good to see you. Let me keep reading over here. It's a lot to read, and I know it's hard to understand, but we have to keep. But really, it's really just between was he forced to accept a juror he didn't want, and sadly, in Letitia's case, that's exactly what happened. I know that he was an alternate, but he still ended up being on. Well, he still voted. He got to vote. That's the sad part about it. Okay, let's keep going here. All right, we acknowledge that in People versus Botham, this was in Colorado in 1981. We mentioned several possible measures that the trial court might take to ensure a fair trial in face of massive pretrial publicity, which we know Stauch had massive pretrial publicity. It included those measures that enlargement of the number of percentage of challenges, which they did give extra challenges. Our discussion of remedial measures in Botham was in the context of resolving the trial court's denial of the defendant's motion for a change of venue and was not intended as anything other than passing reference to various possibilities which might accommodate the competing interest for free press and fair trial. In light of our holdings in Blades versus Defoe, this was also a Colorado case, that a trial court commits reversible error in granting peremptory challenges in excess of the number prescribed by the CRCP. A stronger case can be made for precluding the enlargement of the number of peremptory challenges in a criminal case since the number is established by a statute. All the way around. Okay. This is number 15. One possibly could read the second part of the Sabali test simply to mean that the defendant must show only that he was deprived of the right to challenge the prospective jurors by reason of the use of a peremptory challenge to excuse the other suspect juror who should have been removed for cause. A defendant would satisfy that showing by removing the suspect juror by peremptory challenge and by exhausting all challenges on other jurors. Since those actions demonstrate that the defendant was impaired in his ability to change the composition of the jury, being placed in the position of using the peremptory challenges against the prospective juror, whom the trial court should have removed for cause but did not. The facts in Sabala, however, belie that this reading. The defendant in Sabala satisfied the first part of the test by using the challenge against the suspect juror and by exhausting all available challenges. It seems, therefore, that Sabala's opinion intended the second part of the test to require some allegation or demonstration of the defendant that he would expend an additional challenge on a specific juror who either was biased or the challenge for cause on some other ground. For reasons discussed, the text, we reject the requirement. So there you go. And this was all about a case that is just like Letitia's case. We're going to go up here. This was the People versus McGrander. And in that case, the Supreme Court ended up overturning it. Okay, so they delivered the opinion to the court, and there you go. Okay, so that's the exact same thing. It is the exact same thing that happened in Letitia's case. Exact same thing. Now, let me pull up one little thing. I want to see what they did about that case after the fact. So let's go pull it up over here. Okay. Okay, versus Colorado. It was overturned. I want to know if he was retried or not. I'm going to see what they did about it. Oh, boy. Okay, so we got a new trial, overturned. Got a new trial, okay. Or did they file the writ? Here we go. Okay, so in that case, okay, hang on, let me pull it. Oh, let me just pull it up. I'm going to pull it up right here. It's be easier to read. It's too small on the phone. Sorry, guys. Okay, Magruder. All right. Okay, here we go. Oh, come on. We just looked at that, you silly thing. Okay. Hang on. Okay. Let's see. Is he going to look at for it? Okay. Okay, where'd he go? Why is it not looking? Let me go back one. Let me see if I can find this again. Hang on a minute. Why is it not showing that to me? We just read it. This is crazy. Oh no. Is this the right mouse? No. Okay. I don't know. All right. Hang on. Well, I just wanted to know if they got a new trial. Did they file a writ? What did they do with this case? And right now it's trying to tell me it doesn't know, and I know it does know. Okay, so we'll look at it one other place to see if we can pull it up there. Supreme Court. Boy. Biased juries. Overturned. Let's see. And it was Magruder. I think that's how you spell it. Okay, let me see. Boy, oh boy. Hang on. Magruder. Ah, come on. It's not letting me spell it right. Here we go. Magruder. Come on now. All right, go. Let's see. All right. Okay, here we go. Let's get down here, Magruder. All right. Okay, let me look at. I'm gonna have to look at this one other way. Hang on a second. All right, now stop it. All these things are just popping up now. Y'all go away. All this little shit's popping up on here. I'm like, no, no, go away. Stop doing that. Stop doing that. So not now. Let me go back over here and see if I can't find. Oh, oh boy. Hang on a second. I got to go back one more page over here to find out the right name here. I want. Oh, there it is. Hang on. Here we go. How are we spelling this? Let's see how we're spelling it so we can get it right. Oh, come on. All right, just a second, guys. Okay, hang on. You know, when you want to look up something or you want to do something, it never works right, does it? It just never works right. I don't know why that happens that way, but it's like, wait a minute, where are you? Come on. Okay. Let me pull this back up over here. Let's see. Go back one. Let me see. Go back one. Let's see. Let's see. Come on. I'm going to go back to the first page. Okay. Hang on just a second, guys. I want to get to the first page of this little thing that we looked at. Mm. It's McCrander. No wonder, stupid. All right, let's go see what happened on McCrander. I was spelling it wrong. God dang it. Sorry. McCrander. Overturned. Colorado. Biased juror. Okay, now let's go back to it. Okay. McCrander. Here we go. Okay. Now, let's see. I want to find out, did McRander, sorry, McRander get a new trial? That's what I want to know. Or did they file the writ? Let's see what they did on that. All right, here we go. Come on now. It's thinking. Yes. Yeah, that's what I want to know. Did it or not? Okay. It's still being cited, but it says, listen to this, because it's telling me, well, it's decades old, and it's not wanting to tell me if McRander did get, okay. Well, now listen to this. It's the exact same thing, but McGrander did not get a new trial. So is Stauch going to get a new trial, or McGrander did they file a writ? Now I've got to go. I don't want to go down that rabbit hole because we've already been on here for an hour, and I don't want to be 5 hours trying to find this. But anyway, I mean, I don't understand what would be different, and why would Letitia get a new trial, but Mr. McGrander did not? It's the same exact thing happened about a biased juror. The exact same thing. Somebody was related to somebody who worked in the district attorney's office. That is wild. But let's look at this. I want to just show you this right quick. Let me share this page because I know we all want to look at it again and we want to listen to this crazy ass. Because they're going to show if she gets the new trial, they're using all the same evidence. They cannot bring in new evidence. That does not happen. So let's watch her for a second. Here we go. Let's share our screen and go on over here to this. Here we go. And we're going to let it play, and we're going to enjoy watching this fool.
You had with her, the forensic interview that took place over a period of 3 days in November. Okay, I'm going to play some clips of those interviews with you. But before I do that, going into this interview, do you have any concerns that Ms. Stauch may not be truthful with you during the interview?
Of course.
Deficit, right? That we talked about yesterday?
Of course.
And so with that, Your Honor, and some of these clips are shorter than others. I know you may be more comfortable sitting there, but if you want to get in your wheelchair and go somewhere else, we can do that.
Wherever I could see it more clearly, because I have not seen it as clearly or heard it as clearly as I would like. If there's a better spot, that would
There's a TV right behind you, and then the other TV's here. So you can work out whatever you want to do, Doctor. I mean,
let me figure it out.
You tell me, and then we'll start when you're ready. Over. We're going to go.
Hold on a second.
I wonder, can we move this back a little, and can we see? Can I hear this?
Okay, just found the answer. So in 1992, for Mr. McRader, which is the exact same thing that happened. I'm sorry, McRander, the exact same thing that happened in Letitia House's case. They actually did. Hang on a minute. The state did file the petition for writ of certiorari to the Colorado Supreme Court after losing a ruler in the lower court. I would like to know exactly what happened then. Let's see. Let's see what it says. Here it is, right here. Okay, just a second. I'm gonna see if they accepted the writ of certiorari, if they did something else. In my opinion, the judge is responsible to know. Yeah, you're right. He is Cinderella. He is absolutely responsible. It is his fault, and I say that I know it's his fault, but I just still like him. I can't help it because I think Judge Warner. I don't know. It is absolutely his fault, and I don't think that he'll be. I don't think that he'll be the person that is. I don't think he's going to be the judge this time because of that. I'm not sure, but let's watch. Okay, yes, they did file a writ on Mr. McRuder. Here we go. I'm saying his name wrong, but yeah. So they might follow Writ on her too. We will
Clearly.
see.
You're gonna be able to you're gonna be able to hear it clearly. We could also get you in a wheelchair and put you right here. So that would be easier.
Well, why don't we try it? If it isn't clear,
I just
we can
wanna watch
pause
the-
and go.
Yeah,
Yeah.
well, here's the deal, doctor. I'm going to ask you some questions after the clips. Okay. And so this one's, I think, only about 5 minutes long. We're going to try it from sitting there and see how it works out. And then we can go to plan B if we have to.
Well, yeah, we certainly could. What I would like to do is grab a pad or something so that if something strikes me that I see, I can jot it down and recall it.
No problem.
And I can
Do we have a
just
pad
Oh,
or something?
boy.
while you're when you come back. It's okay.
All right.
When you come back, if you hit both of the green buttons so the perimeter lights are out, it may help her see a little bit better.
Okay.
That? Yeah, and the other one. Yep. There you go.
So for the record, we're going to start with People's Exhibit 729, which is an interview that took place on November 15th, 2022 in the morning time. And before we hit play, doctor,
So interesting.
we have a
Watching her
freeze
act an
frame
ass.
here of the video. Obviously,
Of the what?
it's just the video is paused so we can
Yeah.
see the image. Do you see Miss Stauch there in the center of the video?
Yes.
Who are the other two people behind her?
I see Caitlin and I see the foot. I assume it is of Josh. Is that, I'm not sure. Is it?
Mr. Tlaney?
Yes.
Now, are you seated where Miss Stauch is looking right now?
I think that you can see, I'm not positive. I think those are probably my papers. And so I would have been seated across from her, looking at her and where they could have been in my peripheral vision.
So we're going to start the video at 11 minutes and 5 seconds, and we're going to stop it at 15 minutes and 41 seconds.
Can I try to fix this seat so that I can see what's going on?
It doesn't move. You'd have to adjust your.
I'm just trying to turn it.
Oh, okay. It will turn all the way around. There you go.
Okay, we're going to hit play then.
Okay.
What you call your attorney?
Well, I don't necessarily recall names, but like, I'll like to say,
When you talk to him, like, what do you call him? So I can call him the same.
no, I mean, for example,
Mr. Meeting or Josh.
I don't know, Josh.
You go, Josh. Yeah. Do all of you?
Yeah.
We should hear it better, but it's actually the
Like
recording.
Maria called him Band-Aid. No, like Maria sometimes calls him Band-Aid.
She is called B-A-D-J.
Like that would be like, it's like Spanish for asshole, but like, that's all she gets mad at.
But they always asshole.
Yeah.
Really?
I mean, he's not really an asshole, but yeah, that's hard. No, no, it's,
But,
I don't know Spanish, but she does. Well, only, yeah, the basic, but if you probably never, she knows Spanish.
who knows?
Maria does.
Maria is such a dumb point.
Yeah.
That's in any other language.
I know that my friend said she's taught Russian or.
But, Brandon is sitting for.
I don't.
And you're not aware of any Russian kind of aspect of you.
I know I've been to like a lot of countries and ended up there and I've had to adapt to them and I know that I've been able to talk to people there.
We're certainly just sort of what they're telling you. I'm very John.
I've been to all the islands, all the Caribbean islands.
Yeah.
And I've been to Dubai.
So I need to sit back further and just, it's too hard to see her from here. Can we move perhaps I can just move the wheelchair over there and.
You know, Dr. Lewis complaining again. I really wish they would have had a better sound system there because it made it so hard to hear. Even in the courtroom, I know they were having a problem with it. It's not just what we're hearing here, but I mean, it doesn't matter whose channel I went to. Every channel, they had the same problem with the sound system. Anyway, here we go. We'll keep watching.
Look
Sure.
up here.
I can help you. We paused it at 1311.
Thanks.
Let's see what,
See what we can do here.
yeah. And if we just move that around there, maybe,
Yeah, that's what we can do.
yeah, okay.
You want to sit back?
Let me see if I can see.
So demanding, isn't she?
This looks a whole lot better.
That looks better.
Yeah, let's see.
Okay.
Damn woman.
How's that?
It's better.
Yes.
I think, however, I think this is better.
Okay, that's fine. You'll just need to, if you're going to be asking any questions or give any answers from there, you'll just need to speak up so everybody can hear you because the microphone's not there and there are jurors behind you.
And it may be easier, like when it's a question, then I'll just
Okay.
turn her that way.
We can do that.
Good, Mr. Young.
Yeah, that's fine.
Okay.
Okay, we'll go ahead and resume the video at 1311.
What the date of this, just so I have.
Sure, it's November 15th, 2022 in the morning. Okay, here we go.
She's a princess. She wants to divide everything. She's a princess. She wants to divide.
She's not part of you, or
She is.
and so just that one part you said.
She's risky. Like, she doesn't look as like, she's very risky. What do you call it? Like, risky. Yeah, like. I'm gonna say it, like, get me in trouble.
Yeah.
So that. Can't go out, pray a lot. I'm not a partner.
You're not a part of it. So I was just beginning with the.
So like what happened is something really happens where they're like really stressed out. I can be at like work and be okay and something stressful will happen and then I'll just end up right somewhere.
End up on the plane. Do you know how you got?
It's like my body goes through the motions. Like obviously I gotta get a passport, buy a ticket, but then I don't really remember doing all of it.
You don't remember.
I know it sounds crazy, but
No, it just.
but like, okay, so like. If you see my credit card's by me, and I'm like, oh, okay, obviously she did it, because obviously it's under my name, it's easier, and my mind's gotta know that that's who's credit card, and I comes to be able to pay for it, but then at the same time, like, I won't know I've done it until I'm on the plane, and I'm like, oh, okay, I'm going to this place, or I'm going to that place.
Find yourself somewhere. Not even the plane.
I did a lot, even sim tests. We just drinking wine, I'm like, oh, I didn't remember this wine bottle. Simple things like that, all the way up until being in another country. I did that a lot where my daughter's even texting me, and they're like, Mom, it says you're in the middle of the ocean. I'm like, oh, I am.
Because, and her,
One time I was in Jamaica.
so you were there, fine.
Oh, I got a plane to live in Jamaica, but I was also at work that hardly even let me in with my.
Well, so maybe Josh can look it up.
Okay, we stopped it at
Damn,
15.
it's so bad.
Okay. So I'm more than happy to help out.
Oh, I'm sorry.
Oh, don't tell me they're going to drag her back up there to that chair, are
That's
they?
all right. I did not get all of her words there, so.
Oh, God.
If the question I ask you, if you want to have us replay something, we can do that, okay?
Or perhaps if someone could reread it and,
I'll do my best to paraphrase. How's that?
great.
Okay.
Mhm.
In the beginning, you asked the question about how she refers to her attorney, Josh. You remember asking that? The question you ask is, do all of you call him Josh? Do you remember asking that question? Why did you ask it that way?
You know what? That's my question too. To me, it seemed just like Dr. Lewis was leading her into Maria Sanchez coming out with, do all of you address him that way? She knew what that cue meant, absolutely knew what that cue meant. This is just made up garbage, but we have to watch it because you know what? It pisses us off just enough. Here we go.
I think something interesting that where she had talked about other,
Damn.
and that was, I did not make that up myself, that it came from other entities of some sort. I don't recall the earlier part, but I, knowing myself, I know I wouldn't introduce it, it would have been something.
And I guess, yeah, can the jury hear okay, Your Honor? I just want to make sure.
Looks like it.
Okay, great.
We're getting thumbs up. It's all good.
She talked about Maria having a jail call and speaking Russian. Remember that?
There was something there about the Russian, yeah.
Did you ever see a jail call where the defendant was speaking Russian?
Hell no.
I don't recall a jail call, so I didn't.
That would be something important to you, would it not? If she's saying that, and then lo and behold, there is a jail call where she's speaking Russian, that could corroborate what she's saying, right?
Well, it could. I have to see it kind of in a bigger picture because I knew it had, in retrospect, but it has special meaning because much later, I believe, in my interview, she starts to speak in what sounds like a Russian accent.
And Dr. Lewis, we're going to play that.
Well,
We're gonna,
Oh boy.
this is the first time I'm aware that I did not recall that she had mentioned the Russian at this point. But
Come on, let's go.
it's some kind of entity that sounds like.
and we'll talk about that more when we get that portion of the video. We're gonna play that portion where she's speaking in an accent. Okay?
And one other issue here was, and that puzzled me, but I didn't pause there, was when she said, part of her, I thought it might have been Maria, spoke Spanish. And so I kind of caught my ear from my essence. I too, did anybody speak Spanish? I don't know whether any speak it or whether this is part of it is that sounds.
And there's nothing in the record whatsoever, including the records that were given to you by defense, that indicates the defendant has ever spoken to anyone in Spanish.
As far as I could determine, but I sure wanted to know.
Yeah, sure.
It's possible.
Yep. She tells you that she's been to Dubai as Jasmine, and Jasmine's a princess. Remember that?
Do you remember exactly what movie that's in Dubai and what the Jasmine is and who the Princess Jasmine is? Remember that movie from Disney? Good Lord.
There's a lot of stuff there.
Jesus.
If she had, in fact, been to Dubai, that'd be something pretty easy to corroborate, right?
I suppose. I don't think I took it that.
Christ.
You mean you don't think that she went to Dubai?
Are you saying Dubai, really?
Yeah.
Wish I could speed this up.
At that point.
Okay, so she's making that up?
Well, if she's making it up, or that is a fantasy. Like when we have dreams, and they're very real, and we think we've been there, that at that time that she had been to Dubai, she has a whole history of going to all sorts of different But she has gone to which
Look at her face.
here
She's laughing.
Well, the history would be documented because there'd be plane tickets, there'd be family members knowing that she was gone for a period of time, things like that that you can corroborate, right?
if at the moment I thought that was an easier thing to corroborate. Yeah, I think that it was testimony.
What about Alaska? Remember her talking to you about Alaska later in the interview? How
Oh, yeah, I had trouble with Alaska because
you know what?
Went there, and I think she had gone there.
I meant to say Australia. I'm sorry. I think
You had the same thing I did.
we were having the same problem. She never said she went to Alaska. She said Australia, right?
You did say Alaska.
Oh, she did?
Sir.
Okay.
Well, she did go to Alaska.
Not only that, your head is spinning when you stuff this stuff. But later on, I'm pretty sure that she had a husband who was stationed in Alaska. So I was in real suffering. And that she Alaska, and I looked at I think in my notes I had down that I think there's really Alaska.
Alaska happened. They lived in Alaska. Okay. That was my fault. I meant to talk about the Australian trip where she says her and Harley went over there and she blacked out and was on a beach and doing crazy things, she said, and then realized Harley was by herself. Remember that?
It's something like that. And I'm relieved that you were as confused.
And we know there's nothing in the record to indicate that she's ever been to Australia.
Yeah, right.
She also tells you in this clip that she changes personas when she's stressed out. Remember that?
Yeah.
Is that consistent with dissociative identity disorder?
Yes.
A triggering event?
Yes.
Okay. We're going to play the next clip now, okay? We're going to go to, just have a second. We're now going to jump to People's Exhibit 731, which is your interview. What's the date of this? Would be on November 16th, 2022 in the morning. We're going to start this clip at 1 hour, 31 minutes and 50 seconds. And we're going to stop it at 1 hour, 47 and 22 seconds. No, that's for the record, doctor, just so the record indicates what we're playing. Okay. Go ahead and play.
You're being projected as some monster and like you don't know, like looking around and you like, this is not me. I don't do these things and I don't. You know what I'm saying?
This made this more. Is it possible that it did state? And
If I did, I didn't know I did or did not intentionally do it. You know what I'm saying? There was no intention to harm anyone. That would be a local mine. You see what I'm saying?
because, I'm
Yep.
again, I did not see him. What? See him? Where did you see him? As said, I did not do that. I did this, not to put that, whatever. But this is one thing that she keeps saying. She didn't do, or else it gives, you do get some pretty wacky stories about you think. There is a possibility. It's not clear then. What? Do you think that's possible?
Oh, I said that from the beginning, but I was all over the place because I really, same job.
Is it possible you did that everywhere on state?
I was in a one state.
Could you stay in one of these states where you were involved?
Oh, yeah, I've said that definitely. I know that, but I was not an intention to hurt Shannon. Like, it was never like, no, absolutely not. I love Shannon. I took care of these kids since they were 5 and 2. I've had these kids from coast to coast, country to country.
Yeah.
Like, that's not, what do I gain out of hurting a child? Absolutely nothing. Like, I lose everything in my entire life. And not only is it about me being hurt, but other people around me. And if I'm sitting there telling you that I care about all these people, there are other people hurting this. If I was going to hurt somebody, why would it not be these people that are hurting people? No, it would not be to hurt a child. You see what I'm saying? Like, absolutely not. Would not be an intention to be like, okay, that's it, you're done for the day. No, like, that's not how it works. I don't feel like I'm doing things right, you know, to do that. I don't work my whole life to do things right, to just be like, today's the day, I'm just gonna blame my entire life and everybody else's. That's not how it works. These people here do this, so I don't.
What does she mean by that? It's not how it works.
I mean, you don't take somebody out and go shopping, do this, do that. You don't go buy somebody Valentine's candy to knock them off the planet.
That day you were putting out.
Yes. So I don't understand this. That's just not how it works. You don't buy somebody out clothes for this amount of time. You don't go do this, you don't go do this. Like, I don't get it. I've had these kids in Mexico, Alaska, all these places. Now I have a scratch on their body.
Tell me what's going on. Were you really in Australia?
Yes.
When?
I think it was 2017 or maybe 18, maybe.
How did you just run?
I went with people. Get my records to see where I went at. But I went with there's, I think it was Sam. Oh, Christina, Sam. Other people.
And took care of that.
I don't think they live with us then.
Sitting from time to time, able to get away from this life.
Yeah. Yeah. And it was especially like they were gone for the summer. I just be on. If you get some of because while I paid for it, I paid for it. Yeah, like that was my life. I would rather packing up also just taking everybody back home to South Carolina and taking care of everybody. My life was much easier than that. Because I can help there. But no, their grandma. No, Landon's mom.
Landon.
Which was Gannon's mom's mom.
Yeah. And this is Gannon's
Grandma.
grandmother. Help with.
She helped me when we lived there and I had the kids. She helped me. She's the only person helping. But I also had other people there that could help. Support system, yes. Everything. If I could call ID, I could help. I had other people who programs that I could be like, all right, I need to go do this. I could drop them up here for the day. I had support.
I first saw Josh. I asked him what and he's for a while, but he was saying was there, right? And he said that he left a list, gave him a list of 12 explanations that he gave for what happened when
Listen real
Because
carefully.
then I'll have a flashback or something, but I don't know if that flashback is a cool flashback or not.
yeah.
And I'll have a nightmare about something, so I'll know the nightmare was a nightmare, but the nightmare wasn't real. So then I'll wake up and think that's really going on for hours and hours and hours and hours. Then sometimes I'll have something and I'll try to put together something and it's like, it's really happening. Because I told you earlier that I think if something's really going on, if this is real or not, remember I said I thought this was just one big nightmare. But so any of it, it's all running together, because sometimes I don't know what's going on, it's really not going on, you know what I mean? Then 1 minute something can happen and I'll switch personality and someone will say in the other personality, no, this is what really happened. You know what I mean? Then I'll hear like another voice, so not schizophrenic voice, easy. And it'd be like my other voice, tell me this. So it's like going back and forth, back and forth, back and forth, that I drive me so absolutely nuts. So when you ask me why people tell you 100% that I remember, sitting on the couch, somebody knock, being in the garage, remember that I remember I being in the garage, and I'm going look at the windows, look at someone outside, seeing someone downstairs. That was the things I 100% remember, but running around frantic, not knowing what's going on. So that's what I guess. It's like this dream or fantasy or that you have that influences what you think about. But I don't think it was just the neutral. But I don't know. I don't know. It could be. I don't know. There's people or something. I don't know. But I'm saying though, but you don't know because, well, one person's telling me this. How do I know? Because this person could be trying to go with that person. You see what I'm saying? Because who knows what that person was really doing? You see what I'm saying? It doesn't matter. Told me. I know, I'm not talking about them. I'm talking about what this person was doing. How do you know? Because 1 minute I was doing this, next minute I was doing this, but another person was doing this because I was doing experience. So how do we know?
Who is we?
Whether we're in some computer state, and it's not possible to remember what happened.
It's not going to work for me because I'm not like that. I have to know answers. Dude, I wouldn't care if it was just a random person on the street who was a bad person. Yeah, I wouldn't care. Because they would just be a bad person. Yeah. I don't care. But you're like that. See the news every day, bad people, bad things happen to bad people. But when bad things happen to good people, it's hard, especially when I'm sitting there lost. You know, you're sitting there lost because you're really knows. There are probably little things that you should remember what happened to get rid of. And it's where he's tossed and this or that, it might have to do something. But it makes sense, it's a good memory for.
Yeah.
And there's there's probably a good reason for all of that. And, you got some sense. There's a lot of preference. But let's try to find out why I simply believe that it's wrong.
Yeah.
God.
With innocent crime. Okay.
I think he's going to ask a question now. And then, Dr. Lewis is going to ramble.
I would have just lived, but he asked me just a kid. I don't know your face. I don't know about your face, kid. I'm charges. But who else to begin? He didn't want me to leave at night until hour. God, I should have just did it. Isn't that a brilliant idea? No, but at least you've been saved. At least you've been on the East Coast saved. Everybody was saved. He wanted to go with me. He knew I was leaving. He wanted to go with me. He did. He said, whatever. I mean, and I could stay with you and stay along me and it was fine. And his mommy, his nana, his poppy, and whatever. The East Coast, yeah, to the East Coast. Is that what your mom? No, his mommy. Whatever. No.
His family.
Yeah, his family lived there from the other to.
Yeah, his mom. They were related.
Yeah, he knew I was leaving to go back.
You know what? Right there is when everybody realized that there was somebody in the room with her, because notice the defense attorney was in the room with her talking to Dr. Lewis there, which is so inappropriate because that's when she starts acting out and putting all this on to prove that she's trying to prove that she's crazy, right? But we know she's really not. But let me tell you what I found while we were listening to this. Okay, and this is directly toward the McRader case and Letitia Stauch's case. As of May 2026, let me take this other earbud off. The Colorado Supreme Court has not yet announced whether they will grant the Certiorari to review the state's appeal in Letitia Stauch's case, following the April 2nd, 2026 ruling by the Colorado Court of Appeals that overturned her conviction, and the state has a window of time to officially petition the High Court for review. Legal experts and local analysts have weighed in heavily on how likely the Colorado Supreme Court is to accept the state's request, why they might deny it the Certiorari. Clear statutory laws. Oops, hang on. I'm going to quit now. The appellate court pointed out that the trial judge made a direct error by violating a strict state statute. Colorado law clearly states that a juror with a familial ties to the prosecuting district attorney's office is implicitly biased and must automatically be dismissed. Then there's the entrenched precedent, and this is going to be big. The appeals court heavily relied on a long-standing precedent, including People versus McRander, for the framework, which mandates an automatic reversal if a biased juror is allowed to deliberate. Legal analysis note that the Colorado Supreme Court rarely grants certiorari simply to change a well-established constitutional rule. But then there's this judicial split. This is why they might actually listen to it. They might take it on. The judicial split. The decision of the Court of Appeals was a 2-to-1 split decision. The state will use the dissenting judge's argument to try to convince the Supreme Court that a review is necessary. The preemptory challenge argument. The dissenting judge argued that because Stauch's defense team still had unused challenges, they could have used a challenge. Extra strikes to remove jurors without giving a reason. They should have used one to remove the juror themselves. The prosecution will ask the Supreme Court to clarify if the defendant must exhaust all of their strikes before an error is considered automatic for reversal. What this actually means and when it's going to happen? The El Paso District Attorney's Office stated that while they are partnering with the Colorado Attorney General to fight the Supreme Court review, they are simultaneously preparing for a full retrial. If the Supreme Court ultimately denies their certiorari, the case will immediately return to the El Paso County to begin the jury selection and the process all over. So yes, they are going to file one, and yes, it might get listened to. Now we're going to finish listening to this we're going to finish listening to the rest of this, and then I'm going to have to say bye-bye. So let's keep going, because I always catch, when I'm listening to her talk like this, I always catch little things I didn't notice before. Here we go. All right, let's go.
To the East Coast. And he was like, just take me to me. I said, son, it cannot. It's kidnapping. Your dad would have me hand over kidnapping, because even though I'm your primary caregiver, I can't just take you. And if I would have just did that, everybody would just be fine. So instead, right? So what? You gotta add that to the mix. Add that added on to me, trying to figure out. I was trying to leave, but yeah, I have to make sure that they were safe. Because if I didn't want to leave them safe, you don't realize that the kids late night again. If I would have left them, they would not have been taken care of. Yes, money's not everything. They would have had how they needed financially. They would not have anybody to take care of their academics. They would not have anybody to take care of their school stuff, like, oh, it's just a day at school. Oh, it's this. They wouldn't have had that. Without me, they had none of that. So they would have lost all those things. They would have just been thrown in babysitters. Who would have babysitted them?
Did you ever cross your mind that maybe Dad was there?
No, absolutely not. This was my plan. I could not just take them to South Carolina and drop them off with my mother. Should go ahead. And if I did that, they were in just as worse hands as the guard I'm taking care of them. Right? So the plan had to be add more to my plate to figure out how am I going to get them safely to their mom so she could get custody back. But at the same time, she needs a house. And in order to get custody back, the woman can get custody back if I help her, because I'm the one that reason we got custody was because of me. So I can help get custody back to her. How am I going to do this? Do it correctly. Make sure she has a home.
Killing again.
Gannon doesn't need to die. What are you talking about? Gannon dying has nothing to do with that. I didn't come up with any idea of Gannon dying. My point is getting him safely to his mother. I would have been the plan. I could not get him that day. I told him Wednesday I would have worked out then with her. But talking to her, giving her a home, I can't just go buy her a home. That's not simple. You see what I'm saying? She's a drug addict. Drug addicts can't listen. They repeat the same thought over and over and over. So I didn't lose the battle. Should have just took them with me, started the school cross country, and then just been like, oh, well, one of y'all need to figure it out how to come back here. That's what I should do. Love that day. That's what I should do.
Okay, we started at 1:47:17. Thanks, Mr. Toomey. That's right. So I'm going to ask you a few questions about this clip we just saw. And I want to kind of start where we left off, where she's talking about kidnapping and Gannon wanting to go to South Carolina. You remember that?
I found the entire thing incredibly confusing. She had to take care of Gannon, and she had to protect.
Just answer yes or no.
I was kind of, what in hell is going on here?
Okay, and Dr. Lewis, Mr. Toomey is going to ask you some questions when I'm done. If we can just focus on my question, and then if there's other things you want to add, I'm sure Mr. Toomey can ask you about that, okay? Is that fair?
I thought I was responding to it.
No, I want to talk about, well, is it that unusual that an 11-year-old boy wants to be with his mother? And you think that might have an impact on his stepmother, Miss Stauch, the fact that Gannon wanted to be with his real mom?
I don't think that this demonstrated that. There was something incredibly puzzling about who wanted to be with whom she loved, whom she was taking. I found it utterly confusing.
Do you think that might be a stressor that Miss Stauch talks about? The fact that an 11-year-old boy says, I want my mother, not you.
I don't think that this is what heard there.
Okay. Well,
I don't think we heard that. It's a possibility in another story, in another world.
well, let me just ask you, do you think that's a stressor? The fact that an 11-year-old boy tells his stepmother that I want to be with my mother, not you.
It may or may not, depending on a relationship, depending on depending on so many factors. It's just speculation.
And do you remember in the clip her saying that I couldn't leave. I couldn't leave them by themselves. I was the only one taking care of them, or words to that effect.
Yeah.
And you know that she had been searching on her phone about moving to Florida by herself, looking for one bedroom apartments and looking for another man, that kind of stuff. That was well before Gannon was killed, right?
I don't.
Several times during the interview, you look to your right and appear to be talking to Mr. Cellini about this is evidence that she may not remember anything. Things like that.
I was trying to figure out from him, what do you make of this? Is it possible she doesn't remember this? I'm trying to see if he understood better what was going on there.
Well, Ms. Stauch could hear everything you're saying, right? Ms. Stauch could hear everything you're saying, just like we could.
Absolutely. It was,
And she had already been evaluated by the state hospital and found to be legally sane, right?
they had said that she was.
And she already went through this process where she talked to two psychologists explaining what happened and things like that. And now she's talking to you after that. And you think it's okay to say she may not have memory recall of what happened in front of her.
Yes, it was kind of an open question to Mr. Tony. And also, really, it was open to her also. You remember what was going on. In my mind, it was incredibly wasn't clear that she was making complete sense.
And a couple times in this clip, you asked her what we refer to as a leading question. In other words, you said, do you think it's possible that you were in a peculiar state at the time of this? Remember asking those questions?
Yes.
I think it's dangerous to plant those types of words into a defendant's mind when you're doing a forensic interview.
Well, I think that if this has not come up previously and it has not been part of the common knowledge that she did go into these kind of, it was sort of broken. What do you think was happening when we were thinking these things? It did not make sense. And what was making things so confusing?
Okay.
And was evidence, questions, other data that she did seem to go. After this was the rush. Already, it wasn't adding, oh, gee, you go into these states. We already knew from that this happened. I think it's really possible this really did.
Well, but she's never heard it from a doctor who's doing an evaluation for her insanity, that the doctor thinks that she was in a peculiar state. That has an impact on someone, doesn't it?
I believe that I was reflecting what we already knew from previous discussions, and that I was not introducing a new idea, but that this was an established occurrence, and that possible that this you are in the fun. I didn't know.
Okay. Your Honor, the next clip is about 7 minutes long. We can play that or whatever the court wants to do as far as lunch goes.
I assume you're going to have some follow-up.
Probably.
Clip. It's probably better to play the clip nearer in time to when the follow-up is as opposed to.
I would appreciate that.
Okay. All right. Ladies and gentlemen, we will take our lunch break. I have everyone back in the jury room at.
All right. So let me just say this. Okay. There are real cases of DID. However, Sybil was not real. In 1958, she wrote a confession letter saying she made it all up. All right. But let me tell you the real cases that are diagnosed, that they have the background, they have the testing, this is proved. This is absolutely proved. These people actually have DID. And we know that Letitia Stauch is not one of them. Now, we know that they talked about Billy Madison and Sybil and things like that in her trial, but though they're not real, okay? But a lady named Kim Noble. Kim Noble is widely considered by modern psychologists to be the gold standard of genuine severe DID. Here's her verification. She underwent extensive testing over 2 years by leading psychology professors at the University College of London. They proved via brain scans and cognitive testing that her distinct personalities have complete amnesic barriers, meaning her identities do not share memories and cannot access each other's thoughts and switch spontaneously. Her alters lives. Here's her alters. She lives with over 20 distinct identities, many of whom are accomplished artists. Each personality paints in a completely different and unique style. Herschel Walker. Yes, I'm saying Herschel Walker. Exactly. The NFL Heisman Trophy winner. The background. The former Heisman Trophy winner and NFL star went public with his diagnosis in his book, Breaking Free. This was in 2008. The verification. Unlike malingerers who use DID to escape criminal charges, Walker sought out psychological help privately long before entering politics. His diagnosis was verified by trauma-focused psychiatrists. His alters. He developed distinct competitive and aggressive alters to cope with extreme childhood bullying and trauma. He used therapy to help his alters communicate and safely coexist. Chris Costner Sizemore. The background. She was the real-life woman behind the famous 1950s case study, The Three Faces of Eve. Okay, this is real. The verification. While the movie dramatized her life, her actual psychiatric condition was real. Unlike Sybil, extensive independent medical reviews over decades confirmed she suffered from genuine dissociation resulting from terrifying early childhood experiences. She eventually achieved complete identity integration later in life. Anna Lynn McCord, the background. In 2021, Hollywood actors from 90210 and Nip Tuck publicly revealed her diagnosis of DID. Her verification. She was formally diagnosed by a neuropsychiatrist after undergoing SPECT brain scans that show the unique neural patterns of a dissociating brain. Her alters. She explained that her mind created protective, aggressive split personality names like Little Anna at age 13 to survive a childhood abuse. How doctors know they are real versus faking. This is very important. Psychiatrists use specific medical baselines to catch fakers like Letitia Stauch while validating real patients. The brain changes. Real DID patients show physical changes on functional brain scans like MRIs and SPECT scans. When a real patient switches alters, the blood flow and activity in their hippocampus and the prefrontal cortex change in ways a person cannot consciously fake. It's very interesting. Shame versus attention. Real DID patients usually spend their entire lives trying to hide their condition because they are ashamed or confused by their memory gaps. Malingerers usually show off their alters suddenly, perfectly, and dramatically when they need an alibi, just like Letitia Stauch. Anyway, so that is the end of our show today. I hope you enjoyed it. I hope you learned a lot about the writ of Certiorari and why it's going to count in Alex Murdaugh and in Letitia Stauch's case. Both states need to file them with the Supreme Court to try to get their convictions affirmed. You all have a wonderful night. I'm going to come back tomorrow. I think we're going to do. I think his last name is Weiss. Sprinkle Donut will be with me, and we're going to come live tomorrow and do a different kind of a show. Anyway, you all have a wonderful evening. I'm sure I'll see you all in chat somewhere along the way tonight. And as I always say, go hug your babies. Life is short, and your time with them is even shorter. And with that note, I'm going to say goodbye, good night. Hey, hit that thumbs up on your way in or your way out. I really need to get this work into the algorithm. And without your thumbs up, it's just not going to happen. Thank you, folks. Have a good evening. Thanks again. Bye, guys.